Welcome to today's webinar, Coronavirus Update, Is Your Business Ready for the Employment Changes? My name is Anna Hobson, and I'm on the marketing team here at hrsimple.com. Today's presentation will be about 60 minutes long. If you would like to ask a question, please submit it through the chat box. To view a recording of this webinar, please go to youtube.com/hrsimple. hrsimple provides federal and state-specific manuals. All of our state-specific manuals have been updated with brand new chapters this week to help you during the coronavirus pandemic. Brand new chapters on COVID-19 in the workplace include New Families First Coronavirus Response Act required poster, the Families First Coronavirus Response Act, a chapter on telecommuting, and handling pandemics. We also provide federal manuals such as the Hiring, Firing, and Discipline for Employers Manual that our presenter, Frank Day, authors. Frank's book goes over topics such as employee personnel files, pre-employment issues, and more. Today, you can use code APRILWebinar10 to receive 10% off any of our products for attending today's webinar. Frank is author of hrsimple's Hiring, Firing, and Discipline for Employers Manual, as mentioned, and he has successfully represented national retailers, healthcare providers, and various other public and private employers in matters arising under the FLSA, the ADA, FMLA, ADEA, and various other federal and state statutes. He has extensive litigation experience in many different forums, and he has helped many clients prevail on summary judgment and at trial. Frank frequently serves as a faculty member at employment law seminars, and he has published articles in the ABA Employment Law Newsletter, the Tennessee Bar Journal, and the University of Memphis Law Review. So on that note, we're going to get things started and hand it over to Frank.
Hi, I'm Frank Day. Thank you, Anna, for such a nice introduction. I realized as we were going through it, I might need to update my bio on the webpage, but I think that's a very good summary of what I do. And first of all, I'll say I'm very happy to be with everyone today, and I hope that the information I'm going to share with you is useful to your business and helps you make some informed choices in a difficult time. So first thing I'd like to do is let you know a little bit about our firm. So I'm a partner in our Memphis office at FordHarrison. I'm a partner here. We have offices across the country. We're a national law firm. We represent clients, well, international clients and clients in the United States that range everywhere from, a lot of the industries that Anna just covered from my bio. One of our major clients are the airline industry, the airlines themselves. We represent restaurants, retailers, automotive. So basically every industry across the country we represent. I am based in Memphis, Tennessee, but I have a national practice, and that's really made possible and facilitated by the fact that my partners across the country, we have expertise in varying areas, and we really work well together to be able to help our clients find the right solution to their problems, whatever it might be. So my contact information is obviously in this PowerPoint, and we'll be happy to share the PowerPoint with Anna and with any of you if you'd like it. So a starting point for today is, okay, so what's our agenda? Let me tell you a little bit about how I got involved with coronavirus. So about 4 weeks ago, the coronavirus was in the news, but it really, I know maybe messing up my timeline a little bit, it was about 4 weeks ago. It was in the news, but it was not the big issue that it is today. But as a law firm that represents employers in all manners of employment law, we said, hey, if this becomes a big deal, or if there's going to be issues that arise from it, whether it's a huge deal like it is now or not, so 10 of us, 10 partners, agreed to be part of our coronavirus task force. At the time, I really did not realize what I was getting into. I figured that, I think like many of you, figured this would not be a huge deal because we've never seen anything quite like this. And so volunteered myself to become an expert on COVID-19 and the legal issues that arise from it. And of course, as all of you know, this issue has exploded. There's legislation, there's new standards for various issues. And so one thing we've done as a firm is we have covered the COVID-19 related issues for all of our clients in industry-specific ways from various perspectives, and have been giving, I would say, especially those of us who are part of our coronavirus task force, have been giving advice and counsel to employers, I would say pretty much 100% of our working time for at least the past 2.5, 3 weeks. And so there's very few issues I think that would come up that we have not addressed. But I will also say that the one thing that has remained constant is everything continues to change at a very fast pace. So we have been on the very front end of this and have analyzed laws and figured out how there's going to be interrelationships between laws, what employers should do, et cetera, from the front end. But we're still ahead of the curve when it comes to the regulatory agencies, and we're still having to wait for some guidance from them to answer some of the questions. That being said, I think that we're in a very strong position to address almost any issue that can come up in this context. So general overview is, we're going to give a general overview. We're going to talk about the Families First Coronavirus Response Act. I just call it FFCRA. That's the common abbreviation. So I may just throw in FFCRA. I'm referring to Families First Coronavirus Response Act. Then we're going to discuss some general employment-related issues that arise in this pandemic type situation, and we'll have a little time, hopefully, for some questions. So let me give you an idea of, so we talked about the fact that we formed a coronavirus task force. So some of the issues we've put together and addressed range from employee attendance, working remotely, the impact of travel, how you structure essential travel, leaves of absence, what impact that has on benefit plans, how you pay employees who are unable to work, who are just fearful, who have underlying health conditions. There's so many different reasons that impact whether employees show up to work, don't want to work, etc. There's a range of issues, and then you see at the bottom of this slide we just list a number of different statutes that all come into play here. So this was an overview. So that was kind of an overview of a range of issues we've discussed, but the next slides are just going to give you an overview about what's available on our webpage. So as being part of our task force, we've pulled together resources from all of the different locations that we're using, and we've also created a lot of original materials that address issues of law, that address state stay-at-home orders, that address isolation or quarantine orders. And so the page that you're looking at right here in the PowerPoint is an example of one option. This is directly from our webpage. So each of these links are ones you could follow to get specific issues on these topics. Once again, just flipping, this is links available on our webpage. So this is industry resources. Airlines are one of our, in terms of, I would say, practice areas representing the airlines, that's one of a big part of our practice. But we cover a lot of different industries with industry-specific information available through the links on our webpage under our Coronavirus Task Force materials. Also, there's immigration issues that are specific to a lot of the travel restrictions, to furloughs with individuals who have visas. Immigration is not my specific practice area, but we're covering this issue from all different angles. So these are also resources available on our webpage. I'm pointing this out because it's a great resource that you could probably answer at least the basic questions from these. The other thing is the newest law that's relevant here is the CARES Act. And the CARES Act is a stimulus package. I know everybody's heard about it on the news or has read about it in the Wall Street Journal. It's roughly 960 something pages of legislation. We have some materials that are already available on our website that addresses the CARES Act, but it is more complicated legislation, and we're going to have more materials coming out about it in the near future. So we will be having a firm webinar on this issue, and I talked to Anna about possibly doing one here through hrsimple as well, but we should have that coming out soon. In the meantime, as a general overview, so what is it that all businesses need? And there's a lot that really falls under these categories, but every employer needs to have a written COVID control policy. You need to be able to understand the FFCRA. If it applies to you, if it doesn't apply to you, and even if it doesn't apply to you because you have more employees than the threshold, you're going to have employees who don't necessarily understand that. So you're going to have issues that arise. You're going to have employees seeking leave for these reasons, and you're going to have to figure out, even if you don't have to provide it because you don't meet the threshold, then you're still going to have to address these issues and figure out what your policy is going to be, and you're going to need to do it in a way that makes sure that it's even-handed and doesn't cause disruptions. Very difficult. What we found is it can be very difficult for employers to balance the competing interests. So that leads to implications and potential liability that can arise from decisions. Unfortunately, we're in a situation where some businesses are doing great right now because they're essential and the products they create or the services they provide are in very high demand. Others are in a very difficult situation because their businesses are closed for a range of reasons, closure or lack of business. And so there's mass layoffs, et cetera. And so there's notification laws that apply there. So today, there's no way for us to address in great detail all of the different issues that arise in this context. It is an unprecedented situation. It has never occurred in our lifetimes. The last time anything comparable to this occurred was in 1918 with the Spanish flu. So I will say that it's been interesting for my perspective as a labor and employment attorney, because typically the laws that I'm helping clients address are ones that have predated my practice of law. This is a situation that is brand new. The laws that are coming out are brand new. How existing law applies in this situation is unique, and it really is a situation in which having expertise in the labor employment area has been very helpful, especially in the resources we have as a firm to being able to give very effective advice. So without further ado, I'll say if you do not have a COVID-19 control policy, you definitely need one. It's not rocket science what's included, but there are essential elements. We could discuss all of that. I think it would just take up more of our time than getting to the substantive issues, but make sure you have one and make sure you have proper disclosure policies from your employees to make sure you get the information you need in order to make decisions to protect your workplace and employees, while also making sure that you're communicating with them in an effective way so that they know that you're responding and being proactive about the situation. That'll help control a lot of the problems that arise, like unfounded and unreasonable fears, et cetera. So the FFCRA. This is a very simple slide, and I wanted to keep it very simple because what we're about to talk about is going to be a lot of different elements that are included in a paid sick leave portion of the law, and then another section of the law that is EFMLA. So there's a lot of qualifying reasons under the paid sick leave portion, and there's a lot of details we're going to discuss. Some of the slides are going to get rather dense and full, but that's typically not the way I would do an in-person presentation, but here where I believe the PowerPoint will serve as a good reference for you in the future, I feel like it's useful to go ahead and include it. So what we're going to talk about first under the FFCRA is going to be the paid sick leave aspect of the law. Then we're going to talk about the other aspect, which is separate but related, which is EFMLA. So the paid sick leave portion, and for that matter, the EFMLA, they only apply to companies or employers, as I should say, because that's even broader, with fewer than 500 employees. So if you have fewer than 500, this law applies to you. Now, there's been a lot of debate about why Congress would limit the application of the law to just employers with fewer than 500. The answer politicians tend to give is that that larger employers are already providing paid leave benefits of some kind, but I think the reality is much more in line with the cost associated with extending it to large employers and giving them the payroll tax credit would be far more expensive. So I think there's some debate there, but anyway, the point to take away from this is it only applies to employers of fewer than 500. Now, before we start moving on to specific elements, there's another part of this that's highlighted on this slide, and that is the paid sick leave provisions are only available to employees to the extent that the employee is unable to work or telework because of certain COVID-19 related reasons. So it's very simplistic, but it's easy to start focusing on whether or not certain standards are met without considering whether or not the reason the employee is unable to work or telework is because of one of the qualifying reasons under the statute. I've had lots of questions that really focus on that very issue that says, oh, well, this satisfies the criteria, but they're already off of work. So the fact they're already off of work and there's no work available precludes them from meeting this definition. So the effective date is today. So this law goes into effect today. It applies to all employees, no matter how long they've been employed, and the exception is healthcare providers. I can't get into this in great detail today, but the Department of Labor has published guidance that defines healthcare providers very broadly. And so if you make medical equipment, if you're a medical supplier, if you're in the medical industry and you have fewer than 500 employees, or even if you just service and have contractual relationships with people in the medical industry, it's possible that you're exempt. I say possible because that's something you would need to get very specific advice on. But I raise that because the definition provided by DOL is very broad. So let's get to the reasons. So there are the qualifying reasons for paid sick leave under the statute. So assuming it applies to you in the first place, there is reason 1, 2, and 3. The first 3 reasons, qualifying reasons, are all related to an individual, to the employee, him or herself. So number 1, the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. 2, has been advised by a healthcare provider to self-quarantine. That's directed to the employee. The employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. So that's 1, 2, and 3. These first 3 are specific, and I want to make sure I make a point to treat them separately because it matters in terms of what benefits are provided and it impacts tax credits. But that being said, we move on to 4, 5, and then 6 is kind of a catch-all that's for the regulation. So we don't know what that's going to be, but 4 and 5 we'll address really quickly. The employee is caring for an individual who is subject to a quarantine or isolation order or has been advised by a healthcare provider to self-quarantine. And 5 is the caring for a son or daughter. This isn't in the slide, but under the age of 18 because the child's school or place of care has been closed due to COVID-19 precautions. So 4 and 5 are to care for others. 1, 2, and 3 are for the employee specifically. They're directed to the employee specifically. So let's talk about what number 1 is. The subject to a federal, state, or local quarantine or isolation order. The question I've been getting is, well, our local mayor or governor has issued a stay-at-home order. Are all employees who are covered by that entitled then to paid sick leave under qualifying reason 1? My answer to that is no. We do not have any guidance from the DOL to the contrary yet, and it is possible that they may come out with guidance to the contrary. But I can tell you, and I will tell you, what the CDC explains quarantine and isolation orders to be. So when someone has a communicable disease, a health department or government agency, after somebody's being diagnosed with one, let's say COVID-19, they're issued an isolation order. They have the disease, and so they're issued an order to isolate themselves from others. So what the healthcare providers or health department or government agency overseeing the issue will do is talk to the person who's infected and find out which are the people with whom they've had direct contact who are at a, let's say, medium to high risk of having contracted the disease. Those individuals are then issued quarantine orders. So the isolation and quarantine orders, generally speaking, are directed to individuals. Now, it's possible that a state order could qualify as a quarantine order, but it would be very unusual. So for the purposes of now, what I'm telling employers is be aware of what an isolation and quarantine order really is, because we do not believe that just a general stay-at-home order that is general in nature and not specific to any type of exposure qualifies. The DOL may disagree and they may adopt very broad guidelines, but we believe that to be the best interpretation based on what a real true quarantine and isolation order really is. So number 2 is going to cover a broad range of employees advised by a healthcare provider to self-quarantine. So if you have employees who have underlying health conditions, such as diabetes or a number of different conditions that have been all talked about on the news, they may go to a healthcare provider who tells them that they need to be off from work because of the risk. So they would qualify under 2, and that's kind of a broad category. 3, experiencing symptoms, that would be acute respiratory symptoms and fever, and is seeking a medical diagnosis. So 3 may last for the whole period of paid leave, but it may not. So we've discussed with 4, it's very similar quarantine and isolation order, and it also incorporates a little bit of 3 with 2, advised by a healthcare provider to self-quarantine. That's when an employee is caring for an individual. And then I think the caring for a son or daughter because school is closed is pretty self-explanatory. So those are the reasons that paid leave is available. So under the paid sick leave, the total amount of time available is 2 weeks or 80 hours. Question I'm getting a lot is, so what if an employee's hours vary from week to week? What you do is you have the option of taking a 6-month average to determine how much that employee makes. You would include for calculating how much they make in a week, each week, any overtime they make, any tips they receive, that has to be accounted for. So as we talked about a second ago, the first 3 reasons we listed were all personal to the employee. So if time is taken for self-care for reasons 1, 2, or 3, the employee has to receive their full pay, either whichever is greater, either their employee's regular rate of pay, federal minimum wage, or the local minimum wage. In almost all cases, it's going to be whatever their regular rate of pay is, which includes overtime and tips, whatever that might be. So as we talked about 4 and 5, those are categories that are time taken to care for someone else. That is only paid at 2/3 their regular rate of pay. So the first example, because we're talking about full pay, that's capped at $511 per day, $5,110 total for the whole period. So it's a higher cap, which is also the amount that goes to the payroll tax credit. And then for any of the qualifying reasons 4 and 5, it's capped at $200 a day or $2,000. In fairness, there's not going to be a huge number of people who are going to be making the $511 each day, or more than $511 each day, or at the 2/3 calculation, $200. So few points on here. It's not carried over year to year. Once the need for leave ends, the employer is not required to provide any further sick leave, and employers cannot force people to find replacements before they take leave. So another issue is if someone qualifies for paid sick leave under any of the reasons, 1, 2, 3, 4, or 5, an employer can't make them use any PTO or vacation time they otherwise have available first. This is a new benefit that goes into effect as of today, and you can't force employees to use some other benefit you offer before they are entitled to this. So how is this enforced? And it's enforced under the Fair Labor Standards Act. So it would basically be if you don't provide the benefits that employees are entitled to, there is a range of penalties that arise. So the Department of Labor can enforce the law, or individual and plaintiffs' attorneys can bring lawsuits. And so I think we're going to see a lot of claims arise from this as well. There's a real question about whether or not, since the FLSA authorizes collective actions, which is almost like a class action, it's just a little different. We can't get into that now, but whether or not there can be collective actions. And so that's a question, whether that can take place. We believe that it's possible. We'll have to wait and see how the law develops. Obviously, you can't discharge someone or discipline them because they seek to take leave or do take paid leave. Kind of self-explanatory. You're not going to be able to retaliate against somebody because they're seeking leave for a qualifying reason or exercising rights. Now, a lot of things have changed over the last week. The Department of Labor has been publishing guidance, and some things have become clearer, while at the same time, some of the Department of Labor's guidance has, I would say, created issues of its own. To explain all that, we have to get very, very detailed, but if you read the guidance and you have a very good understanding of different provisions of labor and employment law, you would see that there's a lot of the interrelationships here that the guidance might complicate. That being said, let's address a few specific issues. So if you have subsidiaries to your company or related sister companies, how do you know whether to count the 500, whether to treat all of the employees of the different entities together to reach 500, whether that's appropriate, or whether you should treat each entity separately? So for that issue, there's some attorneys who are trying to give people specific advice and saying, this is the definitive right answer, this is the definitive, this is exactly what's right or wrong for you. The truth is, it's a multi-factor test that determines whether or not you should aggregate the employees at different entities or treat them separately. And we can't get into all of those here, but it's important to note that those factors exist, such as whether there's common ownership and control, who makes the decisions to hire and fire and discipline, who sets payroll policies, where personnel files are kept and maintained. So there's a range of different issues that are looked at to make that determination of whether you should treat separate entities as one for the purpose of reaching the 500 or treat them separately. I would say be very careful in saying, oh, well, we can aggregate these different groups together to reach 500, because that can have negative consequences for you down the road. If you face an FLSA lawsuit that's a collective action, somebody can say, hey, look, you treated all these entities as one for this purpose, they should be one in this context as well. So make sure you very carefully consider that decision. It can have the implications can be very bad if you don't think it through. Now, can paid sick leave be taken intermittently? It can be if you allow it. The Department of Labor's guidance states that employers don't have to allow intermittent leave. If you want to offer it, there's some specific guidance, whether or not you're providing it to someone who's teleworking, working remotely, or somebody who's actually showing up at your facility. And if you want to get that detailed, if you're going to permit it and you're going to have those situations, you're going to need to look at that. Once again, we could spend the rest of the day going through all of these in great detail, but if you're going to choose to allow intermittent leave, which you do not have to do, there is a distinction in terms of whether you can allow it hourly versus in full day increments, and that depends on whether somebody's working remotely versus working in a physical facility. Now, can we require a doctor's note upon return to work? You know, look, your policies that exist, you don't have to throw them out the window. But at the same time, we do have to exercise some degree of, common sense, and even if it's not common sense, understanding the situation. And so you may or may not, I don't think there's anything that prohibits it, depending on how long the person was out. But the question is it really necessary? So actually think through that, take a look at your policies and figure that out. There are some policies that I've considered recently that do violate existing law. And so obviously you wouldn't want to apply any of those, but general advice is you can apply your policies on return to work. Just figure out whether that's something that makes sense under the circumstances for which somebody's taking leave. So if an employee is terminated while they've already left to go on leave, you would have to continue to pay them paid leave. Let's say if you have to lay somebody off, they go out on leave because they've been diagnosed with COVID-19, they're entitled to their 2 weeks, 80 hours, and they're already out on leave and you have to terminate them because of a layoff, they're still entitled to their leave, paid leave. The inverse is also the case, which is if you've already had to lay employees off because you don't have sufficient work, and then they contact you, I say lay off. Let's say you furloughed them, and I use that term to mean you've taken them off of work without pay, okay? But you're keeping them on the books as an employee. So in that situation, if they're not currently working for you, they're still your employee, and then they have a qualifying reason, they're still not entitled to paid leave under the Paid Sick Leave Act. And the reason is because the reason they're unable to work does not have to do with any of the reasons 1, 2, 3, 4, or 5. They're unable to work because they were already unable to work because there was not work available for them. So that's why I emphasize that language. And there's lots of examples of situations that are analogous to that, where somebody would not be entitled to paid sick leave. So that covers the paid sick leave portion. But as I said, there's another section of this law that is the amendments to the FMLA. Now, the amendment applies to all employers with 500 or fewer employees. By the way, this only counts employees in the United States. It doesn't count international employees, but it also counts part-time employees. So I figured I should have thrown that in. So the amendments to the FMLA, they don't apply to every single employee, only those who've worked for you for 30 days. So just like the normal FMLA, it's 12 weeks of time. And there is a provision under this new eFMLA for paid leave. We'll discuss that in a second. But the only reason under the eFMLA, qualifying reason, is for school or child care related to absences related to the need to care for children because their school is closed because of a public health emergency because of COVID-19. So that's the only reason that falls under eFMLA. So we think, okay, a minute ago, we just talked about that being a qualifying reason under paid sick leave. They're similar, but they're not exactly the same. We don't have to get into the distinctions between one versus the other. For the most part, especially in this situation, the two will apply evenly under the same circumstances right now. There can be some distinctions about whether eFMLA applies versus paid sick leave. It's not the exact same standard is what I'm trying to say, but for our purposes, we can treat them as the same. So that means that an employee who qualifies could be entitled to eFMLA and paid sick leave at the same time. So why does that matter? Well, it matters they're separate and distinct, and the benefits available have to be treated as separate and distinct, but they also kind of go hand in hand in a way, because the first 10 days of eFMLA leave is unpaid. But if somebody is under the paid sick leave provision for caring for a son or daughter under the age of 18 because of school closure, then they're entitled to the pay on day one under the paid sick leave provision. So you have to keep track of these separately. You have to keep track of their qualifications for each separately, accounting for, okay, the first 10 days of EFMLA leave are unpaid, but at the same time, they may be entitled to pay on day one at 2/3 their regular rate under the paid sick leave provision. So once again, once the 11th day of EFMLA, there would then be entitled to, under EFMLA, 2/3 of their regular pay, based on the same factors we just discussed, how many hours they work based on the calculations we discussed. This is also effective as of today. So just like regular FMLA, one who takes the EFMLA is entitled to job restoration. I think everybody will be familiar with that. But this law does not extend the coverage of the Family Medical Leave Act generally, all of the different parts of the regular FMLA, to all employers under 500. So if the FMLA does not apply to you now, and the only provision that would apply to you because you have fewer than 500 employees is EFMLA. That might have been a complicated way to say that, but I think it's still clear. If the FMLA did not apply to you before this law took effect, the only part that can apply to you now is going to be the EFMLA provision. So that's basically what we're trying to explain in this slide, and employees who are out are entitled to job restoration. So you calculate the 500 employee threshold for the EFMLA slightly differently than you do for paid sick leave, because the paid sick leave portion is essentially enforced through the Fair Labor Standards Act, whereas the EFMLA is enforced through the FMLA. And there's two different tests depending on which statute you use to determine whether one qualifies as a joint employer. The tests are similar, but they can lead to different results. So you've got to look to FMLA for guidance there as opposed to the FLSA. If you have a calculation of the number of employees and are trying to figure out whether this law applies to you, you probably should seek advice, because if you make the decision that you should aggregate your employees from different entities or different areas or something along those lines, and you make a mistake and you don't offer the benefit, you can end up facing a lot of liability for people who actually qualified and were denied the benefit. So EFMLA, there's 12 weeks available, just like the regular normal family medical leave. But if somebody's already taken their full 12 weeks or a number of weeks of regular FMLA, does that subtract against what they're allowed to take under the new EFMLA? And the answer is yes. They have that 12 weeks available, and once it's exhausted in any way, shape, or form, regardless of the reason, it's gone for that year. Now, I'm not going to get into the details of how that applies, but whether it's a rolling year, calendar year, when it's available, how much has been used, but that is correct. If they've used it for any reason before they have a qualifying reason to take care of a son or daughter because of a school closure, that time doesn't come back just because this law took effect today. So we've covered the basics of the Family First law with paid sick leave and EFMLA. What are the other issues? We have the Americans with Disabilities Act. We have OSHA. We have the regular FMLA. We have Title VII. One thing that came out really quickly after coronavirus started becoming a much bigger issue in the US was some employers sending individuals of Asian descent home because of fear about coronavirus. Obviously, that was not very widespread because it was very irrational, but there were some issues of some discrimination issues that kind of arose from the fact that the virus originated in China, and so that was something that came up there. And then, of course, the Fair Labor Standards Act, which has to do with overtime, wage and hour issues, that's definitely an issue in many contexts here, but people will address those in a second. The NLRA, okay, so we can cover a lot of different things. So basically, in this context, all the employment laws that apply can still apply. It's just a unique situation. So I'm not going to talk about all of these in great detail. It's just you've got to focus on, make sure you're not just accounting for, oh, the Family First law came out, we have to comply with this. You know, how are we going to take this tax credit how are we going to take this tax credit? We've got an exempt employee who's going to be telecommuting for some of the time, but off for others. Can we take the tax credit? And the answer is maybe, maybe not. It depends. And so there's a lot of issues you've got to very carefully consider before you start making decisions about what you're going to be able to take as your tax credit, and you know, to what extent people are actually entitled to leave, paid sick leave, or EFMLA. So the question under ADA, the Americans with Disabilities Act, first is, well, it's COVID-19. Is that a reason? Is it a disability? And I would say for the most part, no. Generally speaking, influenza is not considered a disability. But that being said, it can still qualify if there's other complicating factors involved, if there's underlying health conditions. Also, if somebody has, let's say, for example, coughs at work. We've seen a lot of this. Some employees are all of a sudden terrified because they heard someone cough or they see someone sneeze. And they're concerned because many people are very afraid. Well, you got to be careful that you don't go too far in protecting, you know, the workplace and people, and send someone home where it's really not justified, and you have regarded them as, you could possibly be deemed to have regarded them as disabled and face liability there. So there is a fine line between being protective of your workplace and also not overreacting. And that is a fine line, and we've been giving a lot of advice and counsel on that. If employees come to you and they're saying they're fearful that they're going to contract COVID-19 at work, use the CDC risk tables. This is very specific advice. There's no way to incorporate all of this in here. But if you're not familiar with that, I'll be happy to direct you to the CDC risk tables. Have an interactive discussion with them about what the risk really is in your workplace. And the CDC risk tables of low, medium, and high risk really do help some people understand that they're not facing quite the risk that they might imagine in their heads. In fact, many workplaces there's far less risk of contracting COVID-19 than, let's say, at a grocery store. So a lot of employees who are just fearful of what may happen to them, if they assess the risk reasonably and in the context of the guidelines, might realize that unless they're going to go stay in their house and isolate for the entire amount of time that this may last, they're not really facing any greater risk at work. So if you are an employer that's open and you need employees to work, make sure you engage in the interactive process, understand what the underlying issue is, that the reason that the employee is asking for some type of leave or whatever it might be. Make sure you assess whether it's ADA qualifying, whether it might be FMLA qualifying leave, in addition to just the Family First, the FFCRA. So make sure you take this into account, and please continue to engage in the interactive process with employees. It's going to help you not just prevent liability, but allow you to make the right decisions when it comes to the application of the ADA, what's a reasonable accommodation. And also, just by engaging in the interactive process, you're going to be able to identify people who may be qualified for FMLA for some reason. You have to give them their notice of rights and their FMLA certification before you designate. Now, this slide is an issue that kind of travel has basically stopped to a large degree, but you are allowed to impose travel restrictions. If somebody, for example, wanted to go on a cruise right now, and we had some employers, some of my clients have called me and said, hey, I've got someone who wants to go on a cruise, and I tell them, fine, if they want to go on a cruise, we're not going to stop them, but when they get back, they're not going to be paid for 14 days while they sit in quarantine. And so if an employee is going to make a bad decision, an irrational decision, right now with the risk level being what it is, like for a cruise or for a vacation, I think that's appropriate, but still need to make sure you do so in an even-handed manner and it's reasonable. So that should be addressed in your COVID control policy we discussed at the very outset. Temperature checks. Employers are now allowed to take the temperature of employees. I'm just going to say this quickly because there's too many details to get in great detail, but it has to be confidential. You got to make sure the proper precautions are taken when you take the temperature, and there's also some OSHA requirements for documentation of that. It's really a lot harder to implement than a lot of employers think. You don't have to necessarily be 100% compliant with every law that might apply there in this context, is my thought. I'll always advise 100% compliance, but I also understand what's reasonable and possible. That being said, it's not just as easy as taking somebody's temperature and having people in a line. Quickly, I'll say, let's say you have a bunch of employees lined up waiting to come into a facility. You're actually putting them at greater risk, putting them in a line because of the close proximity to each other at the beginning of the day. Also, if they have to wait before clocking in, you can face an FLSA lawsuit for off the clock violation. So there are so many issues here. I'm just trying to illustrate them to show you there's a lot more issues here than just addressing the one that's obvious, which is, oh, we can take temperature. Well, think about the implications of that. Now, you can you can ask questions to screen people to identify individuals who may have COVID-19. That should also be in your COVID-19 control policy that establishes some standards for that. Pretty straightforward if you are familiar with what needs to go in there. We put together a lot of those. They need to be tailored to what your issues are and your specific business, but at the same time, it's not complicated to do that. So happy to help if you need one of those. Now, what about requiring medical clearance? You've got to follow the ADA guidelines on disability-related inquiries and what inquiries you can make when and by what means. For now, I'll just say that you need to be aware of that issue and make sure you're not asking for too much information that is not actually related, that's not related to business necessity under the circumstances. I could provide a lot more detail there, but you shouldn't. Here's a great example. This is a perfect example of a situation that went way too far. An employer was very concerned for its employees, and so called everybody on first shift together and says, hey, if anybody has diabetes, any immune disorders, or any other condition that might make you more susceptible to contracting COVID-19, please raise your hand. Everybody, those individuals raise their hands, they get pulled aside, they get asked to go home, and they're going to get paid. Well, that's great. It sounds like a nice thing, but they've just violated a number of ADA provisions because they asked about specific health conditions, which was unnecessary. They did it in front of other employees, violating confidentiality and various other things. So OSHA. Now, OSHA has its own guidelines for COVID-19 that establish basically standards for, basically they're following CDC guidelines, but every agency is going to publish their own materials because that's what they do. But they publish their own guidelines, but the first sentence of their guidelines states that they don't establish any new standards or essentially any new legal standards. But that being said, there's always the general duty clause. And so the general duty clause means if a condition could reasonably expose an employee to serious bodily harm or death, you have an obligation to respond. And so whether or not the general duty clause could be an issue for you is definitely something that would be, I would say, employer specific to your industry, what exposure your employees have. So if you know, for example, that somebody contracted COVID-19 at your place of business, not you think, but you know they contracted it there, it is an OSHA recordable as well. You also have to post a general notice if you confirm that someone who's in your workplace tested positive. You don't want to put their name in the notice or anything else. There's some specific information that you do need to include there, but you need to also be careful not to disclose too much, and you only want to do it when you have a confirmed case. So retaliation for complaints about worker safety, workplace safety, those retaliation rules still apply. If somebody complains that they don't feel like you're doing enough, they're still going to be protected under the regular OSHA rules, even if you were found to be doing what's appropriate. Just a general retaliation rule. So long as their complaint is reasonably based and it's not just essentially to trigger some sort of protection. So can you reduce the pay of exempt employees because of business difficulties? Doing this can, changing pay practices for exempt employees can be tricky. When in California, it's different than a lot of other places. I think everyone knows that the employment laws in California tend to be stricter than everywhere else, except for maybe New Jersey, which is trying to out California. That point aside, be very careful when you're changing especially when you're making changes to how you're salaried. If you're cutting back on what your salaried employees are being paid, just make sure you're taking into account the rules about whether or not you can even do that. You can, but you just need to do it the right way. Under the FLSA, you're obligated to maintain for your hourly employees. You've got to it's your obligation as the company to keep accurate records of the hours worked by employees. You've got to maintain those records. If you end up in a FLSA lawsuit and you can't show what hours the employee worked, you're at a real disadvantage. I'll tell you, those are the worst cases, because employees can claim unreasonably that they were working a huge number of hours, even when the employer can say, I know that's not the case. Doesn't mean they always get exactly what they say, but it's your obligation to maintain records and show that. So while people are working remotely, you still need to make very sure that you're keeping track of that obligation and maintaining proper records. Well, I just addressed the record keeping and pay issues, but you've got to make sure you do that. The WARN Act basically covers when there's a mass layoff, and I'll just discuss this in the context of the federal law. There are states that have their own specific provisions that can that apply more broadly than the federal standard, but the notice that you're required to provide to employees in writing and to, let's say, the local Department of Labor office about a mass layoff, plant shutdown, generally those only are going to be obligations if you have an expectation that it's going to last more than 6 months. So if it's just, let's say, you expect it to be a 30 to 60 day layoff, that you may not have to give notice. There's also an unusual circumstances provision. So unlike, let's say, your business is taking a downturn gradually over time, you see this coming, you're able to give the full notice, this situation really is unusual circumstances. So that may not apply, but I'll also tell you whether you have to give the notice may not apply, but unusual circumstances is heavily litigated, whether or not it actually qualifies. And ultimately, if you're in one of those situations that may fall under WARN, you still should try to comply to the extent you can, even if you don't give the full amount of notice that the statute provides. You can end up in litigation for a long time if you don't do it, at least on the basis where you can. Once again, that's an issue with the specific requirements. We could do a whole hour-long presentation just on that and scratch the surface. So on that issue, you would also need specific advice. So compliance basics, make sure you have a control policy. It's going to establish the framework, not just for your communication with your employees, but what you can ask for, and for basically your approach to complying with CDC guidance on limiting the spread while remaining open. Continue following the FMLA ADA. Account for other statutes, account for other laws in this context. Don't just think about it in terms of, oh, this is the law that applies to, let's say, the FFCRA. You can't look at it and say, oh, well, that doesn't qualify under the FFCRA, we move on. Pay attention to the fact you may have ADA obligations. You may have FMLA obligations outside that context. If you need assistance, seek advice. I know that's a very easy thing for a labor and employment lawyer to say, is to seek advice. But I will also tell you that this is a situation that's very unique. in that my clients and businesses everywhere are in uncharted waters in terms of what their obligations are in a context where there's a lot of upheaval. And I will say that this week alone, well, Monday alone, Tuesday alone, the number of issues and mistakes that we've helped people avoid has been very significant. Now, it's not all mistakes are likely to lead to liability, but a lot of employers are going to be making a lot of mistakes in this environment. If you need help, ask for it. We're happy to assist you if we can. I think we'd be able to, but obviously, whether you seek it from us or anybody else, if you don't know what to do in a situation, you don't have a clear approach, you need to make sure that you come up with one regardless of how you do it. The time you spend on the front end will really help you so very much going forward, because you're going to be dealing with a lot of similar issues that are coming up. And if you're taking an inconsistent approach to the various situations that arise without seeing the big picture, that's where employers are going to end up in a lot of trouble for this. So that covers all of this presentation. It looks like we're very close to the hour mark. We have some time for some questions if anyone has it. One thing I'll say is that if some of the best questions for this tend to be very, very detailed, and happy to answer any that I can. I can provide a response, but you might want some, depending on what the question might be, it might be better for it to be privileged, depending on what the issue raises, what issues that the question raises. That being said, happy to answer any questions I can without putting you at jeopardy with my response. So I hope this presentation.
Sorry, Frank.
No, you're good, Anna.
We do have a couple questions before we wrap up. The first one being, how are you advising employers on how to handle unemployment claims that are coming from student or temporary workers? Does the CARES Act change how an employer would respond?
Okay, so the CARES Act is, it's my understanding, and I'll say because I've not read the full 960 pages. We do have associates working on that and some of my partners working on that, but I didn't volunteer myself for it. It's my understanding that your obligations for unemployment are no different than they were before. It's actually on the employee to seek unemployment, and I don't believe the obligations on employers have changed. Now, what benefits are available have changed to a large extent, and who qualifies has changed to an extent. But I believe, and I'm qualifying this because I've not actually read the 900 pages, but I don't believe the employer's obligations have changed. We're going to have another program on that very issue. I know my firm will, and if you are interested in joining that, we'll be happy to put it together. And I may be able to offer another one of these through with Anna. In the meantime, I don't think that your obligations have changed, but I would need to actually review the law. I've read a lot of summaries, but I'll also say a lot of the summaries I've seen about the CARES Act provide some conflicting information. And so I'm not sure what the correct answer is at this point, and I'm very comfortable saying I don't know when I don't know. So sorry about that, but I don't think your obligations have changed.
Our second question is, do we follow state or federal leave laws?
You follow both. And I'm glad that question was asked, because I said make sure you account for the ADA, make sure you account for the FMLA in the context of the FFCRA, and make sure you account for the FLSA and all of these other things. I know I threw a lot at you, but you also have to continue complying with state leave laws. And so you've got to manage all of those issues in addition to the new ones that are coming out with the FFCRA. And so that's the best answer is yes, you still have to comply with state leave laws. And I can think of some examples of advice I've given earlier this week about that, but yes, just make sure you comply with those. I could get very detailed on examples, but yes, you still have these other legal obligations still exist.
Our next question is, will police be exempt for this sick leave?
Yes, they are. Assuming they qualify as first responders, healthcare providers, and first responders are exempt, and I believe police are the prime example of of a first responder. There could be some people that serve in a role that's quasi-police. I think police clearly qualify, but I believe they're exempt.
Okay, our next question is, if no furlough language contained in collective bargaining agreements, how would an employer go about issuing a furlough plan?
Okay, so when you're talking about it in the context of a collective bargaining agreement, it's something we would need to give very specific advice on and need a little bit more information. That is something one of my partners has been addressing exclusively for companies, and happy to address that with you after the fact. It would depend on a number of things. There's some guidance out there on that very issue, but I think there's more to consider there. So it's a great question, and it shows a real understanding that there's an issue there. It's just we would need to provide some specific guidance there rather than just kind of a general answer.
Sure. Next question is, what if an employee is able to telework but says she cannot because of caring for her children?
That is a fantastic question, and that is actually one of the examples the DOL guidance uses. The guidance isn't perfect, but is able to telework. But if they're claiming they're unable to actually work at all because of caring for a child, it raises a real issue. I think you're allowed to engage in some inquiries to kind of explore that. But if they're able to telework, and meaning capable, they still can qualify as unable if they're saying they have to care for one of their children, a son or daughter under the age of 18, which is the definition. That being said, I'm telling people, look, we don't have to check the common sense at the door. If you have an employee who's got a 17-year-old son or daughter who frequently, is at home by themselves, on a regular basis, you may not be able to refute the employee's claim they've got to care for the child, but at least have the discussion. At least have a discussion. Okay, so why are you unable to do this? Especially if you need them to be doing that. I think you'll also see a lot of employees, once they see people going out on leave, you're going to have some employees who are claiming qualifying reasons for paid sick leave when they're probably not going to exist. And that's going to create some challenges for employers. And you're allowed to ask for certain questions. You're allowed to ask for documentation. You should be getting certain documentation for your tax purposes, because if you want the payroll tax credit, which obviously you do if you're qualified by the FFCRA. Anyway, that covers a lot of issues, but that's a good general guidance, I would say, to that question.
We do actually have about 15 more questions. Would it be possible if I could forward these to you, Frank, and then I can send these out to everyone?
Yes, I will try to get to them. I know that I will say I will do my best to respond. If I guess one of the challenges I've got is I've been kind of working nonstop on this, and so with clients, and so if I could get specific questions, I could try to get back to people as best we can. That's probably the best I could say, but obviously feel free to reach out to me directly if I can be of any assistance to you. There's a lot of people making decisions about how to do things, and we're happy to help you do it the right way. We obviously do this as a courtesy to try to help people be educated. We also are happy to assist you more formally with more specific advice. But anyway, I hope that helps. And Anna, thank you so much for hosting this, and I do hope this has been helpful. I know there's a lot of questions out there, but and we're happy to assist to if we can.
Yes, thank you. This has been a really great presentation. This has been awesome information, and we'll try to get those questions answered. But FordHarrison does have multiple resources on their site, as do we at hrsimple. If you have additional COVID-19 questions, and if you need to review the information again, you can always go to youtube.com/hrsimple. And if you are looking for more coronavirus information or COVID-19 webinars, please go to hrsimple.com/events. As Frank mentioned earlier, he will be doing a CARES Act webinar in the future, and information on that will be posted when it's scheduled. If you need any slides, you have any questions, for Frank or myself, you can go ahead and email me. My email is up at the screen. And just to show our appreciation for your attendance today, I just wanted to remind everyone about the coupon code, April Webinar 10. You can use that for 10% off Frank's book, Hiring, Firing, and Discipline for Employers, or any state-specific manuals that have the new COVID-19 information. Thank you so much for coming out today, and stay safe and healthy, everyone. Thanks again, Frank.
Sure, thanks. Hope you all have a great day.